All right, welcome back to the program. And like I said, we really do not take your company for granted. We want to start our conversation this morning looking at the state of the judiciary. And of course, I told you we'll be having a panel of four, a lady and three gentlemen. And already in studio, I'm having this morning Julie Wayua Madheka. Julie is the Program Manager, Democratic Governance at ICJ Kenya. Thank you, Julie.
Thank you very much, Safin, for having us. I represent the International Commission of Jurists Kenyan section, and one of our key mandates is upholding democracy, rule of law, and human rights. And as such, we engage quite frequently with the judiciary because of its work in administration of justice. From where I sit and looking at the state of the judiciary report that was released the other day, I do believe there are remarkable improvements. We have to appreciate that the judiciary has attempted to actually cover the entire country in terms of having accessibility of courts. There is still a challenge in regards to one high court not being there in one county. But in terms of coverage of the country, there has been deliberate attempts. We find that even the mobile court system that they have deployed has reduced the amount of distance traversed by a Kenyan to seek justice to about 80 kilometers, with the farthest being 230 kilometers. And if you really go back as to where the judiciary came from, give or take 5-6 years, people used to travel quite a significant distance to get access to a court. So I do believe that there is remarkable improvement in that regard. Also appreciating the fact that in this particular strategic plan, which the judiciary launched under the Chief Justice Martha Koome, the Social Transformation and Access to Justice Plan, STAJ, she has been very deliberate about ensuring the multi-door access to justice, which is basically ensuring that you have various forums where you can verse your issue and get access to justice. She has been very deliberate about ensuring that court-annexed mediation is featured in a lot of the courts in the country. Same to the Small Claims Court, which has actually unlocked billions of shillings for persons who are actually having small matter litigations before the court, and as well as improving the issue of access to justice through alternative justice systems. The judiciary has been quite strong. And I believe as we speak right now, they have just launched another Ukumbi in Marsabit. So there is also a deliberate way of ensuring that judiciary is not only offering access to justice through its stricto sensu legal courts, but they're also opening up other avenues for access to justice. And this particular report, the SOJA report of 2023-2024, was the first report that actually documented demosprudence, which is jurisprudence from the alternative justice system. So I do believe that there are attempts, there are making advancements, but as you rightly said, there are challenges. One of the challenges that this report clearly highlights is the fact that the judiciary once again was not funded at the tune of its request. It requested for 43 billion, it got 22 billion. So as such, it was operating at around 46% capacity in terms of financial capacity. But also talking about human resource capacity. The staff complement that the judiciary would aspire to have, they haven't met it. They have been operating at around 40%, 50% capacity. The only court that is actually resourced to 100% capacity is the Supreme Court, because the Supreme Court has 7 judges and indeed all 7 are there. However, for the other courts, down from the Court of Appeal to the magistracy, they are not operating at an efficient capacity, and as such there are challenges in regards to access to justice due to also the workload that is there for the justices.
Right. Yeah, but Julie, in the understanding of a Kenyan who is looking at this institution as the point of last hope, these are people who are aggrieved and they are waiting and looking upon the court to do something about whatever it is that they are aggrieved about. What does that look like? All the issues that they are raising.
For the people we work with, and particularly the poor and vulnerable people, they have decried that indeed access to justice is not as easily gotten as it is for the people with resources, because we still do not have an operational, I would say, legal aid framework. We have the National Legal Aid Act, we have the National Legal Aid Service, but in terms of legal aid itself and the provision of legal aid, we are having challenges because of the fund. So people still do not have access to a lot of advocates who could otherwise provide legal aid because of the lack of resources. So what do they end up doing? They end up coming to the courts and litigating for themselves. And you find that in certain instances where they do not understand the legal processes before the courts, they end up being very frustrated. You can imagine if the 2 advocates on the table are decrying frustration in the judiciary, what about the person who is self-representing? So when you speak to the people on the ground who particularly do not have advocates, they will say that there are challenges. Most of them have resorted to actually being involved in the court users committee so that they can directly speak to the magistracy and tell them the challenges that are being faced by the people on the ground so that they can try and attempt to fix them. For example, in terms of long distances, matters being called for mention, yet someone has to really use all their money to come to court only for them to have a mention and then go back. So those are the issues that are currently being canvassed at most court users committees, how to ensure that justice for the poor and vulnerable makes sense. But there's also the fact that a lot of Kenyans right now are feeling as though the judiciary, which is the bastion of last hope, is actually currently not living up to its mandate. And it's a lot of the issues that we have discussed and we will be discussing around accountability of the judiciary, but also how Kenyans have invested quite a lot in hoping that the judiciary can actually be there when it's needed. It was a sad situation when a lot of when a lot of Kenyans asked the judiciary why it was not responding to the matters that were happening in regards to extrajudicial killings, enforced disappearances, abductions, and also the killing of Generation Z when they were on the streets protesting against the finance bill. There was a laudable silence from the judiciary, but again, the nexus of that is that it actually has to be moved. The judiciary cannot comment until it is moved. So you find that the entire justice system at that point in time was apparently failing the people it ought to serve. So if you ask the people, it's a mixed bag. Some people are saying the judiciary is working, but others are saying loudly that the judiciary is not working.
I'd like to run you through some key numbers that were released the other day on 15th when the judiciary was releasing their annual report. And of course, just looking at the issue of the case backlog, a step forward there, the judiciary reporting that there's been a 10% decrease in the case backlog. Of course, the pending cases now, according to the judiciary, dropped by about 2.16% from 649,310 to 635,262. This comes from a total of 516,121 cases that were filed in the year that ended in June 30th, while 509,664 were resolved. Of course, we are looking at the issue of e-filing and digitization as well, 100% in all courts. But of course, as it stands, 325,621 files have been scanned. Of course, we also move to the issue of funding the judiciary. This is on the case against cases that have been filed against judicial staff, judges and magistrates. And of course, they received a total of 1,115 complaints. Looking at as it stands today, 93% of these cases have since been resolved. Have we seen results? That's the big question that is still pending there. Of course, on the issue of funding the judiciary, a key concern is the issue of the budget deficit that stands at about 20.75 billion shillings. So according to the Chief Justice, despite the gains, with this sort of underfunding, with this sort of lack of financial muscle, it overshadows every other thing that the judiciary has been able to achieve, and also the plans that they have when it comes to recruitment of judges, and also just sort of like making sure there is the necessary infrastructure to deliver justice. So you look at that budget deficit, 20.75 billion shillings. And that brings us to the conversation we had even started having earlier. The numbers I once interacted with the judiciary was looking at a figure of about 40 billion plus to effectively deliver on its mandate. Right now, it's working with a figure of about 20 billion, 22.4 billion shillings in this billion shillings, which still is running short of what they feel they should be having to effectively deliver justice. The funding of the judiciary, Julie, from where you sit, how significant is it in ensuring that they can actually do what they're supposed to do? Yes, they have their cleaning of the house that they have to do, but the funding issue, how is it significant from where you sit?
It is extremely significant. For ICJ, we have been discussing the issue of judiciary funding since the promulgation of the Constitution, and the judiciary fund is actually anchored in the Constitution. And with the judiciary having the requisite funding, it can then develop its programs and ensure that it is kitted to serve the Kenyans in the right manner. So, for example, at the beginning of the year, the projection was that the judiciary would enhance its Court of Appeal capacity by 20 judges. That cannot now be done because they do not have the requisite funding to fund Court of Appeal judges, because people normally assume that Court of Appeal judges are just 20 individuals. But actually, a Court of Appeal judge is a complement, is an office, because that person needs a staff. He needs a secretary, a legal researcher, bodyguard driver, the works. So it is not just getting 20 people in office. It is a big endeavor. You also have the fact that the magistracy is also not funded properly. And you find that the magistracy actually interacts mostly with the wananchi. They are the first point of call for most Kenyans because of also the pecuniary jurisdiction, but also the proximity. So you find that the magistracy, in terms of its complement, it's not yet at its par. We began the conversation by saying that as it is, the human resource capacity of the judiciary is at 53%. Imagine operating your house with a 53% capacity, meaning you basically don't have half of what you need to do what you need to do every single year. So credit to the judiciary for looking beyond the GOK funding, involving a lot of development partners who have been able to alleviate some of its otherwise dire situation that it would have been had they actually operated with the current financial constraints. But that is also telling that we need to invest more. A study was done on 11 jurisdictions in Africa which talked about the issue of judiciary funding and how it can be used as a threat and intimidation tool if it is not well ring-fenced. And indeed, for us to achieve judicial independence, it is important for us to talk about judicial funding. Because if you then constrain the funding of the judiciary, you actually water down the independence of the judiciary. The ideal complement that the judiciary would have is 1% of the GDP. It has never gotten close to that. It has been teetering at around 0.4, 0.5. Yet, you would find that its other arms of government are actually well-resourced. And we know that the judiciary is an arm of government, but consistently we find that the judiciary is the one entity that decries underfunding every single time in the budget. I would opine that if we actually gave the judiciary its complement, its funding, we would then be able to then hold it accountable and say that we gave you the funding that you have requested, show us the results and show us the delivery. But if we keep on constraining it on funding, then we actually are asking it to overperform when it is not well resourced.
So we cannot hold it accountable if you're not even giving the judiciary what it needs.
No, we need to hold it accountable still, but we then need to also be able to push as citizenry, as people and actors in the sector, for it to get its full complement. But indeed, accountability, we have to hold it accountable.
How many, Julie, how many radical surgeries will we have then? Because if we are saying that corruption is a reality within the judiciary, but then we are also poking holes in the effectiveness of the Judicial Service Commission, I mean, my biggest fear is what he was saying, a time when we will now resort to the rule of the jungle and Kenyans would be feeling like, hakuna haja hata nipeleke kesi yangu kotini. How do we avoid getting there? Because we know the consequences of that as well.
I think it's important that we actually do take a moment and appreciate the consequences of the rule of the jungle. I think 2008 was a very telling time and a sad time in our history. And for those of us who are alive and witnessed the atrocities that took place because of the inability of the judiciary to guide the country and steer the country away from that, we understand and appreciate why the judiciary and the JSC in itself were created. So talking about the current state of the judiciary in terms of accountability, indeed the statistics say that 1,115 cases were filed this year, a decrease actually from last year where they had 1,200 cases. I would wish that there was a narrative around why there was a decrease in the number of complaints, because also a decrease in complaints is a very telling story juxtaposed against what the public is saying. So that should also be a cause for concern. 2 weeks ago, the Supreme Court was having its introspection and reflection at Supreme Court at 12. I would opine that it's also important for the Judiciary Service Commission to consider having a reflection of the same kind, whereby they invite stakeholders to really tell them where the shoe is pinching. Indeed, the JSC has representation from the Law Society of Kenya, 2 people, but as rightly said, the numbers from the judiciary are much more. But there's also the Attorney General. there are also members of the public who are there, and they represent all our interests. So what is happening at the Judicial Service Commission where nothing is supposedly seeming not to move? So can we have a conversation around why things are not moving at the Judicial Service Commission? Or at the same time, can we have a conversation around whether Kenyans appreciate or utilize the Judicial Service Commission for complaints? Because there has also been a decry from the Commission that enough conversation is happening in the public sphere around corruption of judges and magistrates, but they're not getting those files. They are not getting those complaints registered before the Commission. So do people even know how to file these complaints? Do we have evidence of complaints filed and no action taken? And I do believe this is then a challenge to the Law Society of Kenya, civil society organizations that work on the issue of democracy and governance, to actually interface with the JSC and ask those difficult questions, because appreciating both dynamics, whereby you have to protect the judges and judicial officers who are innocent until found guilty of the dispute resolution process, but also the client who's then complaining, we need a sort of in-camera conversation whereby the Judicial Service Commission can report and say, this is where we are at in terms of complaints. These are the matters that have been taken for further investigation. We appreciate the way in which a judge can be removed from office. It is not that easy. We require an entire tribunal. And in order for us to have a recommendation from the Judicial Service Commission for a tribunal to be constituted, the evidentiary threshold must be met, because you cannot then move these processes at will, because then they'll be exploited. So there's also a threshold that has to be met. So what are the bottlenecks that the JSC is facing? Is it lack of evidence? Because indeed, we appreciate that sometimes corruption is very sophisticated. Do they not have that kind of evidence before it? How can we assist as lawyers? Because for us, even out here, when we are campaigning for the judiciary to be fully resourced, we get backlash and we are told you are resourcing an entity that is morbidly corrupt. So it's in our best interest as well to ensure that the judiciary is clean. So I think it's time that the JSC come out, talk to people, engage the public around the complaints mechanism and how to actualize it. But also ensure that Kenyans understand the differences between appeals and complaints, because there are certain matters that actually Kenyans take before the JSC that actually should go through the appellate processes, whereby someone is dissatisfied with the outcome of a case. That isn't necessarily an issue of complaint, but an issue of appeal. But we have also talked about the issue of the human resource capacity and constraints. If a party is dissatisfied with a matter that they have gotten, or a decision they have gotten from the High Court, for example, and then you lodge an appeal, but the appeal takes 15 years. You are then frustrating this person because you're telling them you cannot complain before the JSC because this is judicial decisional independence. You need to appeal. The appeal takes another period of time that is quite long. And at the same time, they don't have a recourse before the JSC because they are pending this appeal to be determined. So you find that someone is stuck between a rock and a hard place. And that is why the public is decrying that there is a challenge in the judiciary and there's a need for a conversation around judicial accountability. I would not be the first proponent for vetting, because, again, it was subject to abuse. The reports are telling that some people just did not like how you speak. And they used the vetting process to get rid of certain good judges and magistrates because they were too tough, because they were too bold. So it is subject to also manipulation based on the interests, political interests. So I think let's work with what we have as per the Constitution. Let us strengthen the JSC and let's hold it to account. I would then opine that it's important for the lawyers to have a conversation with their representatives at the Commission for a candid conversation around what is happening there, as well as for the others who are working with the judiciary to also, particularly for judges and judicial officers, to actually ask for judges and judicial officers who are representing them in the JSC to hold the judges and judicial officers to account, because one bad apple spoils the basket. If they continue watering down these matters, then the entire judiciary gets the flack. Thank you.
And we can imagine the darkness that we will be in if that happens. Exactly. Because the judiciary, I see it as the only institution that from my point, should and needs to be objective, because the other arms of government sort of like have at the background the political interest that needs to be served at the end of the day, which sometimes can come in the way on some of the things that are done in this country. And Julie, what do you think? Is it a creation of the media? Haven't we seen instances in this country where cases that involve high-profile people drag. This war against corruption, looking at it, is it an area where the big fish continue to swim and the small fish, fry? From where you sit, just looking at instances we've had in this country.
I think, so I have two issues here.
Yeah.
I do the work around elevation of poverty and also looking at the small fish, the mamambogas. And as Agri said in the beginning of the conversation, in 2017, the National Council on Administration of Justice actually released an audit that stated that 70% of the persons who are in detention in pre-trial are actually poor, vulnerable, and they're there for petty offences. And translating now into the detention, they were there because they could not afford the fines that were imposed by the courts. So you find that in the detention facilities, we have people who are poor, vulnerable, and indigent. So that is the demographic of people we have behind bars. What does that mean? It means that the people of wealth, the people of corruption, the people who are charged with corruption matters, more often than not, do not go to the detention facilities. Why? Because they can afford advocates, because they can actually mount a proper defense. So, in terms of the anti-corruption war, the corruption war, we have seen challenges, and particularly challenges bedeviling the entire criminal justice system from the corruption, from the entities that are seized with investigating corruption. DCI, ESCC have investigative powers. They are supposed to create files that are actually full of evidence and ensure that they meet the evidentiary threshold so that the prosecution can actually give a decision to charge on the basis of a probability of conviction. Do they forward the cases as they should be? Because we saw from the previous DPP that a lot of the cases ended up being withdrawn because of the promise of evidence to follow after the decision to charge had already been put in place. So a lot of cases were frustrated. I think it was either your media house or another media house that actually brought the DPP to actually answer and ask those questions. Why are matters failing in court? And he did say that at the investigation stage there was a gap. So for the issue of corruption, I think we need a whole of justice approach. We need to start at the investigation level. How is investigation being carried out? How is evidence being collected? How are witnesses being protected? We need to capacitate the Witness Protection Agency because witnesses, particularly of corruption cases, are often targeted. Right now we are seeing that the Adani situation has blown up. But where is the initial whistleblower? He's not in the country. He's not even on the continent because of the threats that are actually on his life and on his person because of what he then said. So I think we need to strengthen the government entities that actually do the investigation, protection of witnesses. But then we need to also call and hold the DPP to account. You need not prefer a decision to charge if you do not have the evidence because, again, that is a violation of the rights of the person who is then charged. You need to return the file to the various investigative agencies and ask them to provide the requisite evidence for you to be able to bring these cases to court. I actually agree with counsel here when he says that indeed once the matters are before court, there ought to be a sort of mechanism whereby evidence can be presented before the magistrate or the judge, depending on the level, and they look at the evidence before them and say that this matter can then be set for hearing and can proceed. Because then we end up not having a situation where the matters are withdrawn in the middle because witnesses are not there. But we also we can borrow innovation from other countries whereby evidence, particularly of witnesses who are vulnerable, can be taken in camera and preserved early enough. Because we have seen instances where these witnesses are compromised, but also these witnesses are actually threatened. So let's devise those mechanisms. And I know at the National Council on Administration of Justice, there is an entire committee that is seized of this issue that is going to be developing an anti-corruption framework that is due to be launched very soon. And this framework will actually guide the entire criminal justice system on how it should address corruption, and with the requisite goodwill from all actors, and particularly political actors, we will then be able to fight corruption. And I actually agree in tongue-in-cheek with what the President said at the very end of his statement, that Parliament also needs to be able to safeguard the country. Certain bills should be put in place, including the issue of conflict of interest. You cannot have politicians also engaging in procurement and also service delivery because they are supposed to just maintain their role, which is legislation, of, oversight and the rest. So I think there's been a meddling of the waters, and that is what has created this current conundrum we have in regards to corruption.
All right.